Arraignment is a formal reading of a criminal charging document in the presence of the defendant who informed the defendant of the charges against the defendant. In response to arraignment, the accused is expected to enter a plea. Acceptable pleas vary among jurisdictions, but they generally include guilty, not guilty, and the peremptory pleas setting out reasons why a trial cannot proceed. Pleas of nolo contendere and the Alford plea are allowed in some circumstances. Australia. In Australia, arraignment is the first of 11 stages in a criminal trial, and involves the clerk of the court reading out the indictment. The judge will testify during the indictment process. Canada. In every province in Canada except British Columbia, defendants are arraigned on the day of the trial. In British Columbia, arraignment takes place in one of the first few court appearances by the defendant of the lawyer. The defendant is asked whether he or she pleads guilty or not guilty to each charge. France. In France, the general rule is that one cannot remain in police custody for more than 24 hours from the time of the arrest. However, police custody can last another 24 hours in specific circumstances, especially if the offense is punishable by at least 1 year's imprisonment, or if the investigation is deemed to require the extra time, and can last up to 96 hours in certain cases involving terrorism, drug trafficking or organized crime. The police needs to have the consent of the prosecutor. Germany. In Germany, if one has been arrested and taken into custody by the police, one must be brought before a judge as soon as possible and at the latest on the day after the arrest. New Zealand. At the first appearance, the accused is read the charges and asked for a plea. The available pleas are guilty, not guilty, and no plea. No plea allows the defendant to get legal advice on the plea, which must be made on the second appearance. South Africa. In South Africa, arraignment is defined as the calling upon the accused to appear, the informing of the accused of the crime charged against him, the demanding of the accused whether he be guilty or not guilty, and the entering of his plea. His plea having been entered, he is said to stand arraigned. United Kingdom. In England, Wales, and Northern Ireland, arraignment is the first of 11 stages in a criminal trial, and involves the clerk of the court reading out the indictment. In England and Wales, the police cannot legally detain anyone for more than 24 hours without charging them unless an officer with the rank of superintendent authorizes detention for a further 12 hours, or a judge authorizes detention by the police before charged for up to a maximum of 96 hours. But for terrorism-related offenses, people can be held by the police for up to 28 days before charge. If they are not released after being charged, they should be brought before a court as soon as practicable. United States. Under the United States Federal Rules of Criminal Procedure, arraignment shall open reading the indictment to the defendant and call before he/she is called upon to plead. In federal courts, arraignment takes place in 2 stages. The first is called the initial arraignment and must take place within 48 hours of an individual's arrest, 72 hours if the individual was arrested on the weekend and not able to go before a judge until Monday. During this arraignment, the defendant is informed of the pending legal charges and is informed of his or her right to retain counsel. The presiding judge also decides at what amount, if any, to set bail. During the second arraignment, a post-indictment arraignment appear, the defendant is allowed to enter a plea. In New York, most people arrested must be released if they are not arraigned within 24 hours. In California, arraignments must be conducted without unnecessary delay and, in any event, within 48 hours of arrest, excluding weekends and holidays. Thus, an individual arrested without a warrant in some cases may be held for as long as 168 hours without arraignment or charge. Form of the arraignment. The wording of the arraignment varies from jurisdiction to jurisdiction. However, it generally conforms with the following principles. The accused person is addressed by name. The charge against the accused person is read, including the alleged date, time, and place of offense, and the accused person is asked formally how he or she pleads. Video arraignment. Video arraignment is the act of conducting the arraignment process using some form of video conferencing technology. Use of video arraignment system allows the courts to conduct the requisite arraignment process without the need to transport the defendant to the courtroom by using an audio-visual link between the location where the defendant is being held and the courtroom. Use of the video arraignment process addresses the problems associated with having to transport defendants. The transportation of defendants requires time, puts additional demands on the public safety organizations to provide for the safety of the public, court personnel, and for the security of the population held in detention. It also addresses the rising costs of transportation. Guilty and not guilty pleas. If the defendant pleads guilty, an evidentiary hearing usually follows. The court is not required to accept a guilty plea. During the hearing, the judge assesses the offense, the mitigating factors, and the defendant's character, and passes sentence. If the defendant pleads not guilty, a date is set for a preliminary hearing or a trial. In the past, a defendant who refused to plead was subject to peine forte et dure. Today, in common law jurisdictions, the court enters a plea of not guilty for a defendant who refuses to enter a plea. The rationale for this is the defendant's right to silence. Pre-trial release. This is also often the stage at which arguments for or against pre-trial release and bail may be made, depending on the alleged crime and jurisdiction.